Today, we'll be discussing the botched workplace investigation. We are going to take you through a real investigation and highlight all of the mistakes that were made with a view to helping you avoid making those same mistakes. My name is Dorian Persaud. I am the senior lawyer at Persaud Employment Law. We are a team of lawyers who specialize in conducting workplace investigations and helping you to create healthy workplaces through investigations, training, and proactive advice. So before we get into the topic of the case study and this investigation that just went off the rails, I wanted to get some context from you and just find out how many of you attending today have had the experience where someone has been accused of misconduct and management for whatever reason, whether it's related to that misconduct or just having a dislike for the person themselves. They have it in their mind that they're going to let this person go, and they come to you and they say, look, here's how we see things. We're going to get rid of this person, and here's this allegation that has come up. We'd like you to investigate it. And by the way, if we'd actually like to do this for just cause, because then we don't have to pay this individual anything. So if you could find some grounds or dig up some dirt in the course of your investigation, that would be great. So I'm going to send this poll question out to you, and would love if you could respond to that. Let me know if you've ever encountered that scenario, and we'll give folks a moment to participate before we publish the results. Okay. So I don't know if those results are showing up on the screen for you, but in terms of the responses, we have 80% of you have indicated that you have experienced that scenario that I just ran through, where before you've been able to understand the allegations, and before you even set up the investigation, you're starting with the conclusion already in mind. That outcome is already set, and now you are just working towards that outcome. And that's quite an astonishing number, right? Of 80% of you that have been placed in that situation. And that's a very difficult situation to be in, right? Because instead of approaching the investigation with an open mind and setting up a process that would allow you to get to the truth and figure out what happened here and really be driven by the evidence, you're now pigeonholed into a situation where the end has already been decided, and your process is really geared towards achieving that end. And at worst, fishing or digging for more information to support an allegation of just cause. So again, that's a very difficult position that you're in, and we'll see the impact that has on the process that an HR professional would undertake when they're in that situation and then conducting a workplace investigation, because that's exactly what happened in the case study that we are going to review today. So let's set this up for you. We have the holiday party for this multinational organization, and they are thrilled to be launching their new Toronto office. So they have invited many employees from neighboring states to attend this event and help to launch this event. They have invited clients to be there, and HR head office is located in Illinois, and they've flown in some folks from HR to be at this event. So this is a big deal and a great way for them to showcase this new space and kick off the holiday season. There is a sales employee there, let's call him Frank, and he shows up in a really flirtatious mood and from the get-go, is making some borderline inappropriate comments. So he approaches the hostess, who's greeting all of the guests and handing out the name tags, and he stares a little bit too long at her chest, and he gets his name tag, and he's asking her, what breast do I put this name tag on? And again, just his eyes maybe linger a little bit too long on her. He then goes from there into the function itself and socializing with employees and clients. And two of his colleagues are dressed up, and one happens to be dressed in all black, and the other happens to be dressed in all white. And he makes a comment that maybe one of them could be the bad angel and is tempting him to do something wrong, and the other one could be the good angel and can persuade him to do the right thing. So makes this joke, but there's a sexual undertone in the way that those communications unfold. The party unfolds in the normal course, and there really isn't much of anything as far as inappropriate incidents go until the end of the party. And one of the senior directors in this company's New York office, he's been observing Frank all night. He's irritated by Frank for whatever reason. And at the end of the evening, some employees are helping to clear tables and pack away some chairs. And he says to Frank, hey, look, why don't you help out and be a good team member? And Frank makes a joke about he is the entertainment. He's there to entertain the clients and to keep them occupied. And so he doesn't engage in helping others to clear the space. And this director, that rubs him the wrong way, and he lays into Frank. He just starts insulting him and telling him how arrogant he is and how poor of a team member he is, and what a bad example he is setting for the company. And so he really lays into him and embarrasses him in front of all of these staff and several clients. So it really puts a sour note on the evening. There's no complaint to HR, certainly not that evening. And in the days that follow, no issues. And the company actually sends Frank to New York to do some work and to take some clients and entertain them at that location. In the meantime, what Frank doesn't know and what HR doesn't know is this director, out of New York City, he's really has it in for Frank. And he says to his staff, he's like, look, if Frank looks at you the wrong way, if he says anything to you that you think is inappropriate or that makes you feel awkward, I want you to report that to me and to HR right away. He is zeroed in on getting Frank. And sure enough, Frank attends the office, sees one of his colleagues, makes a comment about what she's wearing, and she reports that to human resources. Frank is immediately sent home and is told that there's been a complaint against him. He's not told in that moment what the allegations are, but he's sent home. He's placed on a paid leave of absence, and he's sitting there now at home wondering what just happened because he's confused as to how these events have unfolded. While Frank is at home waiting to figure out what these allegations are and what's actually going on, HR is conducting their investigation. They have started this process. So they've been in touch with the young lady who came forward with the allegation about the inappropriate comment being made about her appearance. And they hear from her boss, who is the director in the New York office. And he starts talking about how Frank had behaved at the firm's holiday party or that launch event in Toronto. He goes on to share more incidents. He alleges that there was an inappropriate conversation that Frank had with him a few months ago, where Frank was, discussing his relationship with his wife and was doing that in a way that made this senior manager uncomfortable. And HR takes these allegations, and instead of investigating just the complaint that is in front of them, they start contacting other employees in the Toronto office who work with Frank. They start contacting the managers that Frank reports to, and they just start asking open-ended questions about, hey, are there any examples that you can give us of Frank acting inappropriately? Has he said or done something in the past that could be a breach of policy or that you found problematic? So they go on this big fishing expedition to just see what else is out there. And again, these are not people who have come forward alleging any misconduct. This is HR actively going out and trying to fish for allegations that may exist out there. And that's a big issue, because now what HR has done is they've compromised the confidentiality of this whole process, right? They haven't just taken the allegations and investigated what's in front of them. They have opened this up and contacted now a handful of employees and made it very clear, hey, look, we're not just asking you to let us know if anything inappropriate happened at the Toronto event. We're specifically asking you, did you see Frank do or say anything inappropriate? So there's no question in anyone's mind what this conversation is about. And by the way, everybody knows that Frank is on a leave of absence. And so you see this picture starting to build. You see the problems starting to build here. And it really starts with this fishing expedition that HR goes on. The other issue and the second mistake that HR makes here is the lack of independence. So when you are faced with a complaint of, in this case, sexual harassment, and one of the complainants is a senior manager, one of the things that you have to ask yourself as the individual asked to conduct this investigation is, am I independent enough here? Can I conduct this investigation in a way that is going to be fair to all of the parties involved? And it was very problematic in this case for HR to identify that there are senior managers involved here. To what extent is HR really going to feel comfortable holding these senior folks accountable? And we'll see that issue come into the forefront as we move through this story. The other issue is the fact that there's allegations of sexual harassment. So we have the allegations of leering at the beginning of the night, and then Frank making inappropriate sexualized comments to several individuals. So when you're going to undertake an investigation, and especially an investigation that involves allegations of sexual misconduct, you should have experience in that area before you move forward, or at least have someone with you who has experience, so that you can make sure that you're taking the right steps and you're approaching the witnesses in a way that is respectful, that recognizes maybe the trauma that they may have been be experiencing because of that experience. There are a host of details and skills and facts that inform your approach to preparing and then conducting those interviews that are extremely important then when it comes to collecting that evidence, analyzing that evidence, and making a credibility assessment. In this case, neither the director of HR or the associates that he was working with had any experience conducting a workplace investigation, much less an investigation that that included allegations of sexual harassment. These were all essentially folks who were sales reps themselves and were promoted into these positions and ultimately found their way to HR. They aren't the traditional, they certainly didn't follow the traditional route into that practice. So recognizing, again, that lack of skill and experience in this area, that was something that should have jumped out to HR and made them think, okay, maybe we need to bring in an independent, a neutral third party here, or is there someone else in the company that has this experience and has the independence to conduct this investigation in an impartial way? The final point I would make on this is, in terms of recognizing, when it's appropriate to conduct this in-house or bring in an external third party, one of the factors that you want to consider is the risk of litigation. And in this case, you're dealing with allegations of sexual harassment, and you're dealing with an employee in Frank who has a material number of years of service and makes quite a bit of money. So if you are going to then, as the company has outlined, if their goal or their intention is to dismiss this person for just cause, well, that's always going to end up in litigation. In very, very few cases is someone going to admit to the misconduct, even if there is misconduct, admit to that misconduct and agree to walk away from their position or accept the termination and be paid $0. That virtually never happens. So again, HR should have recognized the risk for litigation here, and for that reason, make sure that they had an independent third party conduct that investigation for them. The third mistake that is made here is the lack of procedural fairness. So what we would expect to see in these situations is for the responding parties, for Frank to be given, remember, he's sitting at home on a paid leave right now. So we expect that he's given a document that summarizes, look, here are the 5 things, here are the 10 things that folks have alleged that you've done. And we want you to attend a meeting with us to review these 10 allegations and provide us with your response on them. So they don't do that. What they did was, again, they engaged in that fishing expedition. Then they called Frank into a meeting and they just start hitting him with these allegations in real time. And many of the allegations that they then threw at him weren't even related to the comments that were made at the holiday party. They weren't even related to the interaction he had with his colleague in the New York office. These were things that happened allegedly 2 years ago, or things that were said months ago. And he's sitting there spinning, wondering, where is all of this coming from? They, in that meeting, put forward these allegations as if they had come from these individuals themselves. So, for example, they took an employee in the Toronto office and they said, 2 years ago, you made a comment to this employee and belittled her job and made it seem as though her job wasn't as valuable or wasn't worth as much to the company as the work that you were doing. And you spoke to her and your other colleagues in a condescending way. And to be clear, that was information that they gleaned from their fishing expedition. This wasn't an employee in the office actually coming forward and filing a complaint, but they presented all of this as if, again, they had all of these complaints from several individuals. And his head is spinning during this meeting. He does his best to answer the questions. And at the end of the meeting, he asked them for a summary of these allegations that were made. He said, look, I did my best in the moment to respond, but I'm sure that there are details that I missed. And if you could simply send me a list of the allegations and let me know who made the allegations, I would love the opportunity to go through my records and provide you with a more fulsome response so I can fill in any of the gaps that remain after our face-to-face meeting. So the company does that. And surprisingly, the list that they provide in writing is different from the allegation that they raised with him during the meeting. And there's simply no excuse for that. If you know what the allegations are and you are going to put these allegations to this respondent in a meeting, there is no reason for that list to change then when you turn around after the meeting and give him a written list of these allegations. So that was problematic, and I opened the door to or strengthened the case for bad faith here based on the allegations changing, and also potentially raise questions about the credibility of the individuals involved. Are they making these allegations? Have they pulled some of these allegations off the table? It just raised a lot of questions from a procedural perspective. So again, when you start out with a messy process and when you are winging it and when your goal is to really dig up a lot of dirt, one of the things that you're not thinking about is the issue of procedural fairness and how do we handle this interview with the responding party. And the HR department really botched that interview and then made matters worse in their follow-up communications with the respondent. So as was their intention from the beginning, the company, they take the information that they've received and decide that they're going to terminate this employee for just cause. And keep in mind here that the employee, we're talking about Frank, the responding party, he, after getting that list, he gets back to the company and he says to them, hey, guys, I think some of these facts are wrong, and let me give you my side of the story. And so he provides them with his evidence, and he said there were other people around when these comments were allegedly made, so here are some folks that you might want to meet with in the course of your investigation. HR wasn't really interested in doing that. They had the information that they want. They had the narrative that they wanted. They just picked it up and ran with it. And whether it's HR or senior management or those departments working together, they decide we're going to let Frank go. We're going to do this for a just cause. And that's problematic because the employer said in the course of conducting their investigation, the only allegations that they actually substantiated were the couple incidents that happened in Toronto where, again, you had the comment that was made to the hostess about which breast the name tag should go on, and the comment that was made to the two employees about one dressed in black and one dressed in white, and one being a good angel and one being a bad angel. And even on its face, if you take those two things as being true, none of that would rise to the level of just cause for termination in Canada. And that decision then being made to hold these events out, to allege that this employee who's been there for 10 years because he had these two interactions that were problematic, that these two events somehow rise to the level of just cause for termination is extremely problematic. Again, just based on the seniority of this person and the fact that on the continuum of bad behavior, these are behaviors that would fall on the lower end of that scale. So you have here the messy investigation. You have all of the mistakes that have been made along the way. And then at the end of it, the safest thing for the company to do is, just package the individual out, right? You don't need to allege just cause. You just package this person out if you don't want to be in a relationship with him for whatever reason. And that would be the easiest way to go. But now when you let someone go allegedly for just cause, well, now you've just invited a lawsuit. And as part of that lawsuit, it's going to be messy because that person is going to be claiming extraordinary damages. They'll be claiming damages for bad faith because of the flawed and biased investigation that was conducted. So HR took what should have been a really straightforward investigation, but really made a mess of it. And not only made a mess of it, but turned it into a very expensive event for the corporation. So this employee who's been dismissed again, allegedly for just cause, is going to bring a lawsuit and claim damages for wrongful dismissal. He is going to have a claim for the damage done to his reputation because the employer went out there and spoke with all of these employees and maybe connected with clients. They didn't give him any input into what they were. We're not going to say to clients, so there may be damage to his reputation there. But the biggest one is just the damages for bad faith. So there isn't in Canadian case law an independent tort. You can't bring a lawsuit for a negligent investigation, but certainly where an employer conducts an investigation in bad faith and again, looking at this situation, you've got the bad faith as demonstrated by the fact that they made up their mind from the beginning what they were going to do. You've got the fishing expedition, the lack of due process at the interview with the responding party. And you put all of these mistakes together, and this employee, this corporation is facing damages of potentially up to $50,000. There's another case in Canada that's a precedent for that amount where you have elements of bad faith during an investigation. So these mistakes are 100% completely avoidable, regardless of where you start out or what position you've been put in. There's a process that you can follow to get to a fair result. That may not be a result that the employee is happy with, but you can get to a decent result that's going to at least stand up to scrutiny and avoid the significant liability that this corporation is now facing. So when you are setting up your investigations, you want to, regardless of if you've been put in a difficult spot where you know what the corporation wants to do on the back end of this investigation, you can still go through and set up the investigation in the right way so that, again, you're avoiding any extraordinary damages because of a flawed investigation. So you can, number one, start with your independence. Look at the allegations that have been made. Look at who's involved. Do they include senior management? Do they include facts or allegations of sexual harassment or another area that would be complex to investigate, and maybe you don't have the skills in-house to properly conduct that investigation? That would be a reason to recognize, look, maybe we're not going to be independent here, and it makes sense to bring somebody else in. Due process. You want to take the allegations that have been brought before you. You are not out there fishing for more wrongdoing on the part of this employee. You're simply taking the allegations that are there and collecting the stories from those complainants. You are meeting with the responding party, and then if there's a conflict in the evidence that you need to reconcile, you're meeting with relevant witnesses to reconcile that evidence. But you're just following that simple step, right? Nothing more, nothing less, and allowing the responding party an opportunity to know, like, look, this is the case that's been made against you. These are the allegations. And give that person an opportunity to attend a meeting knowing what the allegations are and giving them a fair opportunity to respond and provide their version of events. And then confidentiality is key as well. When you're setting up these investigations, you want to minimize the gossip around these events. You are trying to protect the reputations of everyone involved. At the end of the day, there may not be any misconduct, and maybe these folks are going back to work, which is what happens in many investigations. So knowing that and knowing the harm that could ensue, both to the individual and the risk of a fractured workplace and the gossip being out there, you want to do the best that you can to maintain confidentiality and not engage in a fishing expedition where you're asking everyone to come to HR with whatever allegations they might have against a particular individual. You want to be thorough in terms of how you conduct the investigation. In this case, the employer, they were focused on the allegations that were made against Frank, but they didn't pay any mind to the conduct of the senior manager at the party when he just went off and berated Frank in front of the other employees and clients. So you want to be fair in your approach. That event was witnessed by dozens of individuals. There were other managers at that event. So even if you don't have a formal complaint, certainly from an HR perspective, when there is an incident of harassing conduct, that's something that and senior management's aware of that. That's going to trigger your obligations under the Occupational Health and Safety Act to look into that event. So it's not based on whether a complaint was brought to you, it's whether or not there was an incident of harassment, and your obligation is to look into those incidents. And then when it comes to reporting, you want to make sure that you have that you've reached a conclusion on all of the allegations, that you communicate that to the parties that are involved. In this case, the company decided for whatever reason to indicate that they are taking these two, that of all the allegations that were made, that these two allegations were founded, and they're going to rely on that to assert just cause for termination. What the corporation ignored, again, was the conduct of this senior manager from New York in terms of what he did at this holiday party. But then also the fact that he made allegations in the course of the investigation. He alleged that Frank had a candid conversation with him and made inappropriate comments about or described inappropriate events involving his wife that made the senior manager feel uncomfortable, and that was not founded as part of their the conclusions to their investigation. So essentially, it's left open that this individual lied about that event happening. And on the one hand, then you've got Frank, who loses his job because of the a couple interactions at the holiday party, but you have the senior manager who has berated an employee publicly, who has lied in the context of a workplace investigation, and who is still employed. And that unequal treatment, that unequal application of the company's policies, again, is going to give rise to additional damages for this corporation. So sometimes from the beginning, it looks so easy. We're going to do this investigation, and we're going to get these allegations, and we'll have this great case for just cause, and we'll be able to just package this up really neatly and bring everything to a close. But as you can see, it doesn't go that way. And when you don't follow the appropriate process, when you don't have a framework that is and a process that is going to stand up to scrutiny, when you're making it up on the fly, and when you start from a place where your motivations are off, you can get in a whole lot of trouble and cause the organization a whole lot of liability in the process. So I hope that this case study has been enlightening for you, just to see how easily an investigation can go off the rails, and hopefully you have a better appreciation of what you need to do to keep things on track. We are going to open up the floor now to questions and answers, and I would invite you to use the Q&A function within that chat function to forward any questions that you might have. and answers. And I would invite you to use the Q&A function within that chat function to forward any questions that you might have. Okay, so it looks like we have a question from Louisa here. Okay, when should so I believe the question that we have here from Louisa is, when should an incident be categorized as disciplinary, and when should an investigation be conducted? How do you distinguish between going one route or the other? So in terms of, Louisa, in terms of your question and when you need to conduct an investigation, if there are allegations of misconduct that would violate one of your policies, right? So there's maybe a code of conduct policy, maybe there's a conflict of interest policy, maybe it's harassment or sexual harassment. When you have an allegation that it rises that level where, if it's true, it violates one of your workplace policies or applicable legislation, or I'm thinking of human rights legislation, that would trigger your obligation to look into that event, right? So even before you get to discipline, you have to look into this event and figure out, did this thing happen? Did this person say whatever it was it is alleged that they said? Did they do the thing that they are alleged to have done? And that's where you would then conduct an investigation. And when we say investigation, most often during these webinars, if you've attended them in the past, we're mainly focused on the formal, the bigger formal workplace investigation. But certainly there's no magic to that word, right? At the end of the day, the obligation is to do some sort of a fact finding. So that could simply be an HR associate, going to the parties and saying, hey, we heard that you called someone, this name, during a meeting. Maybe you whispered it under your breath, maybe just loud enough for that person to hear. Did you say this thing? And the person might say, yeah, you know what, I did. I said it. I'm sorry. I was frustrated. I probably shouldn't have said that. And acknowledges the issue. And that's an investigation, right? You went to the complainant, they came to you and told you what happened, and you went to the other party and they acknowledged that, yes, this thing was said, and you just deal with that, in the moment, and that, that constitutes an investigation. But for every allegation of misconduct, you want to do something like that, right? You got to verify the thing happened before you then go down that disciplinary route, because obviously if it didn't happen, or if you got concerns that to the extent it didn't happen the way that it was reported to you, then that's going to impact what, if any, discipline is required in the circumstances. So it's always important to do some sort of a fact-finding, Louisa, before you then make decisions to move ahead and go down the disciplinary route. Okay, another question that we have here is from Aaliyah. And Aaliyah is asking, what would you recommend when bringing allegations to the respondent? Should these be reviewed in the interview and then send a comprehensive summary and allow them to provide their statement in writing? My concern with sharing the allegations ahead of time or before the meeting will be that they'll come prepared, and I can't read their body language and reactions to the allegations, and they may come prepared with a story which may not be true. So that's a great point, Aaliyah. So Aaliyah's question just has to do with, wouldn't it be better, and I'm paraphrasing here, wouldn't it be better if we just give them the allegations in real time at the meeting, and that way the person can't prepare. You get their raw reaction to what's being said. They don't have time to construct a story. And doesn't that give you the best evidence? There are two views here when it comes to how to approach an interview with a responding party. One is this approach that Aaliyah highlighted, where the interview by surprise, right, or blindsiding the witness with the allegations and seeing what you're able to get. The other approach is to provide the party with the allegations ahead of time, give them an opportunity to respond, and then go through that information at the interview. We advocate for so certainly we advocate for allowing the responding party to prepare for the interview, come to the interview prepared, and you go through you go through their story, and it may be the case that it creates a little bit of work for you as an investigator to to pay. There's going to be more details. The person, if they're smart, is coming prepared with not just their version of events, but they've maybe have some evidence in terms of emails or information from their calendar to show where they were or how long a meeting lasted or where this meeting took place or whatever the case might be. But they've come prepared. So it's going to be more work for you as an investigator to receive that evidence, to parse through it essentially in real time as you're receiving it, and then ask the appropriate follow-up questions to determine credibility. What we find, though, is that you get better evidence that way. So when you have all of the information from the complainant, when you have all of the information from the responding party, you then, as an investigator, that's your job, is to take that evidence and wrestle with it and ask the right questions, and ultimately come to the result that makes sense, right, based on what you've received. When you do it the other way and you blindside the witness, one of the risks is that you don't have all the information. So this person has really just been put on the spot, and there's more that if they had been given time, there's more that they recall and relevant details that they'd like to share, but they don't get that opportunity in the meeting. It's not until they leave the meeting and then they're able to, based on what they understand the allegations to be, that's when they start putting things together. So in the case study that we reviewed today, that's what happened to that respondent. He went to the meeting with no baseline, absolutely no knowledge of, what was alleged. And then coming out of the meeting, that's when he writes to the investigators and says, look, here's what I recall from the meeting. Can you confirm? Are these the 10 things that are alleged? Are these the 10 allegations that have been made against me? How can I? Because I'd like to know that, and I'd like to know who made the allegations, so that I can go through my records and figure out, was I even in the city when this alleged conversation take place? Was I, where did this event take place? Maybe there are, maybe I know that there are witnesses that the corporation could interview in order to figure out what happened here. So in the case study that we reviewed, this Frank was alleged to have said something inappropriate to one of the associates in the New York office. He was able to show the company that, hey, look, these are some other people that attended that space with me. They were standing with me when I made the comment to my colleague. And if you meet with them, presumably they'll attest to the fact that I didn't say anything inappropriate or suggestive, or certainly something that would constitute sexual harassment. So that's the information, Aaliyah, that you don't get in real time when the person walks in cold to the interview, and you're putting the responsibility on them after the fact to come up with that information and present it to you. And then, frankly, you're still in the position of, whether you get that information in real time or afterwards, you're still in the position where you then need to pull it all together, right? So you're taking what the person told you at the first meeting, you're taking what they told you at the second meeting, and now you're having to, still pull that together to figure out who's telling the truth. Is there another witness that I need to meet with in order to make a conclusion here? So I understand your point that, do you get, it's based on that raw reaction, does that give you a better feel for what actually happened? And I know that there's some investigators particularly in the fraud space, right? Like where they're investigating financial fraud. In many of those investigations, they will do exactly that. They'll have all of the evidence of the fraud, and they'll invite the person into the room, and then they'll hit that person with all of the bank statements and the transactions and the expense receipts and go through everything. And that person is completely cold going through it. And I know that's the way that a lot of those fraud investigations are done. But I think when it comes to harassment investigations, in my experience. I don't know if it serves us that well. And the more investigations that you do, you will get better at conducting the interviews and knowing what questions to ask and being able to focus on the witness and take notes at the same time. Or these days, because a lot of these interviews are conducted via video conference, you might be able to record the interview, and that way you're not as focused on taking notes, and you can look more, focus more on the witness through the repetition. I think, and doing these interviews frequently, you will get better at conducting interviews and assessing credibility. So we have a special course on credibility, and we'd be happy to share that information with you. It's one of the most difficult things that you have to do as an investigator, and one of my strengths, just is assessing credibility, just because of all the litigation that I did in the past, and that litigation experience of having to ask those questions and drill down on the witness and do cross examinations and really help a court to understand who's telling the truth and who isn't. All of that serves us well when we're investigating cases, and that's that's part of the training that I think a litigation lawyer would have that most folks wouldn't, right? So this is just one of those things that the more you work at it, you will get there. And if there's any resources that you want on that point, I'm happy to send those your way and let you know about the course that we have on that topic. Okay, we have another question from Darlene. The question is, should we tell the parties the meeting is being recorded? Yes, absolutely. If you are recording an investigation interview, you should have the consent of the party to that interview. Just let them know it's being recorded. Ask if they have any concerns, and you can let them know that you're going to be preparing a transcript of the interview. So if they would like, and they'll have an opportunity to review that transcript. So I find that folks usually don't have an issue when it comes to recording the investigation interview. There are some unionized environments that I've worked in where not all members, but maybe certain union members have issue with the interviews being recorded, and that's mainly grounded in a fear of just generally being recorded at work, and that being a sensitive topic in their collective agreement. So again, apart from those very rare instances, most employees are comfortable with the recording, but I would certainly make them aware before you do it. Another question we have here is, I've encountered situations where a disciplinary meeting transforms into a union requested investigation. However, if during the meeting the employee takes responsibility for their misconduct, I assume an investigation would no longer be necessary in such a scenario. Is that correct? So Louisa, maybe that's something that we can chat about in more detail. But generally speaking, if somebody acknowledges misconduct, then certainly that helps you to document you can document the fact, the process, right? That this did come out in an interview during a meeting with that person's union representation. So they were presented with the allegations, or whatever the scenario was, they indicated their responsibility or whatever role they played in that event, and that essentially doubles as an investigation interview. However, there may be elements of the allegations that are still unresolved, and maybe there are other allegations made that this person wasn't involved in, or maybe there's an open question about, to the extent that these things happened, do they constitute harassment or discrimination or bullying or something like that. So you may have to go that additional step with the analysis, and it's not just finding that this person played a role or this person admitted to the conduct in question, but you may have to document whether or not there has in fact been a violation of the policy, and you'll want to do that from a due diligence perspective, just to meet the employer's statutory obligations. So that would be one element that I'd be mindful of. There's another question here about a great question about what AI tools would you recommend for taking notes during an investigation meeting to ensure privacy and confidentiality are not compromised. There are a number of tools out there, and they are getting better and better at doing this work. There are a few tools that we experiment with. One of them is Otter AI. Another one is Fireflies AI, and those are good note-taking, and they're really meeting assistants, right? The app works, like a person in the room sitting in on the meeting, and then listening in and giving you a summary of the meeting. Another way to use them would be not to have them actually participate in the meeting themselves, but to you can upload audio after the meeting and see if the app is able to transcribe it. They are getting, again, it's not a perfect, the technology isn't perfect as yet, but they're very good at recognizing voices and giving you a decent transcription to work from. So those would be two tools that you might want to experiment with, and in most cases you'll have to set up a paid account, I think, to get the better features that they provide. But if you're looking to experiment, those might be two applications that you might want to take a look at. Okay, we have a little bit of time left. I'm not sure if there's any other questions out there. We probably have time for one more. Okay. Well, I want to thank you all for attending today. You'll see I hope that today's presentation was informative, and appreciate you taking the time to join us. You'll see a QR code on the screen there. If you could scan that QR code and leave us a positive Google review, that would be very helpful. We do our best to produce content for you that we think is helpful, that's going to help you in your investigation practice and help you build healthy workplaces. And we want to thank those of you who have attended our events in the past, and if this is your first time attending, we want to give a special welcome to you, and we hope that you'll join us for future events. But yeah, certainly if you enjoyed today's event, we'd love for you to scan the QR code and to leave a positive review for us, and that just helps us to put more of our content out there and let the world know more about what we are doing. Thank you very much, everyone. It was a pleasure spending this time with you. Wish you all the best and look forward to seeing you soon. Take care.